Hello? Hi, and welcome to Raw Law. This is Arkady Frekhtman. I'm a New York City personal injury trial attorney, and we are here to answer your questions live and to talk about your comments. So, welcome everybody. And while we wait for people to join and come into the live, what I'll do is I'll go over our community tab and I'll answer some of the questions. Yeah, and I'm sorry about that. I know there was another one where something was going on with the microphone. I'm not sure why, because this one usually always works. It's a pretty good one. It's called the Yeti. I think the blue Yeti or something like that. It's a pretty good microphone. So I'm not sure why. Maybe I'm thinking another app was using. Maybe I was in my VoIP, my voice over internet protocol, phone system, and maybe that was using the microphone. Computers get so complicated these days, so I'm not sure, but let me answer a few questions from the community tab while we wait for people to join and ask questions live. So here's a question from Mary, and she says, is a neck fusion with plate and screws a serious injury, and how much is that worth? So yeah, absolutely. I mean, a neck fusion is a very serious injury. In fact, the last few that I've done, the one I'm thinking of that I did in the Bronx with a slip and fall, ended up settling during trial for $3,500,000. Then there was another one where a car hit a Con Ed manhole cover that was improperly placed and acted like almost like a ramp, and the car went up in the air. And that one settled for $2,200,000. And then, so those are the recent ones that I've done. And then, of course, there's other cases that I'm handling that aren't going to trial that just settle. Like there was another very nice lady in Brooklyn. In fact, I haven't done a video about her case. I should do it. I should go over the file and maybe do a video about her case. But her case settled for $2.5 million. So those are just some examples from my firm. But of course, fusion is a serious injury because you're taking out the herniation and you're taking out the disc, you're putting in an artificial disc. There's a plate, there's screws that's permanent. You're losing mobility in your neck or in your lower back, wherever the fusion is being done. So it's very serious, very serious, but it depends on a lot of the other factors, like what happened, how much insurance there is, where is the lawsuit pending, what's your overall story or your overall biography, how can we show the overall impact. Is this a life-changing forever injury? So those are some of the issues that come into play. And then she also says, thanks, because on top of the surgery, I also had a tear on my left knee, and I also did surgery for both knees. So yeah, I'll let her know. Give her my number in case she wants to do a consult. And that is 347-566-9595. So if you text me, I can do a consultation. Then we kind of discuss everything. And that's much better because I know a lot of people ask me on these lives, what's my case worth? But it's just a comment. So I would have a lot of follow-up questions in order to give you a proper answer. And therefore, it's better to just do a consult. And then let me see, what questions do we have here? Kate says, hi. David says, does having a multi-level degenerative disc disease of the spine without surgery increase settlement? No, because if the disc injury is degenerative, that means that it happens from the normal painless aging process, right? So you want the injury to be traumatic, meaning it was the car crash that caused it, right? It was the slip and fall that caused it. It was the ceiling collapse that caused it. If it's degenerative, that's what the defendants, the defense lawyers, the insurance companies, that's what they want, because degeneration is like the painless, normal aging process. It's what happens as your bones and your discs and the jelly inside each disc dries out slowly as we age. So everyone's going to have some degeneration, right? If you're 50, you have the spine of a 50-year-old. If you're 30, you have a spine of a 30-year-old. So that's what the defendants are basically arguing, is that they're saying the car crash didn't cause anything. You're expected to have these degenerative changes from being however old you are, right? And so that's their argument. So you don't want degeneration, you want to have a traumatic injury. And then Thaddeus says, how much is a spinal cord fusion worth? So yeah, that's I just answered that for Mary. I mean, I gave some examples like 3.5, 2.5. Usually it's into the millions. It depends on where. So the venues will differ. Like for example, in the Bronx, people are sometimes even getting 5 million, 7 million, in Brooklyn as well. In other counties, I'm not familiar with all over the country. Like maybe I know I did a research for one person in Virginia. I forget which part of Virginia, but a certain conservative part in Virginia. And over there, the highest verdict I saw was like 250,000. So I was kind of, surprised, because in New York, people are getting like 3 million, 4 million. And over there, the same injury, and it's only like 200, 300,000 was the highest. And some are going for even less, right? So it depends on where, it depends on how much insurance there is, how the incident happened, all these factors. And I've done videos about that where I talk about, what are the factors, the driving factors, the catalysts that determine value. So you could take a look at those videos and they explain it. That's why I was saying it's better to do a consultation if you wanted to know value of your case, because just from a comment, it's really like almost impossible to give any kind of, accurate answer. So it's not that I don't want to, it's just like, I would have a lot of follow-up questions in order to give you a proper answer. Oh, he says in Indiana. Yeah, Indiana, I think, is a pretty good venue. I've seen some good results in Indiana, and I know a lot of good trial lawyers there as well that are getting excellent results. Okay, and Chris says, hey, Arkady, love the video you made on my case. Haha. Dropped you a text. If you can get to it when you're free, I'm sure you're super busy. Yeah, sure. No, absolutely. Just drop me a text. I'll get back to you. I'm going to try to also set up a new system maybe by this week or next week, where I'll have like kind of like office hours, maybe like like from 4 to 6 or from 5 to 7, maybe once or twice a week, and then people can just schedule consults themselves, and that way you can just book like a 15 or 20-minute consult, and it'll be free, and I'll just do some consults, and then some of them, if the people agree, we could even record and take out the confidential part, like names or anything like lawyers, but just the general questions, right? The general questions like how we would go about proving the liability, how we would build up the damages, and then that could be helpful for other people. So that would be kind of cool. And I've been doing a few of those, the consult videos. And then Come Along with Uncle Joe says, how about a slap tear for a level 4 and a labrum tear, Compton, California? Yeah, I mean, a slap tear is pretty serious. That's basically arthroscopic surgery, labrum as well. So those, they can go anywhere from like 150, 200,000 on the low end, but if it's more serious, it can go up higher, like 300, 400. I've even had some arthroscopic procedures like with anchors where they get a little bit more complicated, even into like 650, 850. So those could be worth a lot. And California, I think, from what I've seen, is a good venue. And also people are getting to keep their verdicts in California, meaning if you have a trial and you get a nice verdict, like say you get $10 million. Well, in New York, the defendants would just appeal that. And then the appellate division would say, 10 million, that's too high. Take 1 million. Or if you don't like it, do the trial all over again, and just that answer, just them saying that, they don't say it right away. It takes like 2 years. You have to write appellate briefs and they have to read the whole record on appeal, all these papers, just to get them to say that, 2-3 years later. And then they're going to say, do another trial, right? But that's all we're going to sustain because that's what we feel is fair and reasonable based on past cases. You see what they're doing? So they're kind of like destroying the jury verdict. They're lowering it. But in California, from what I've seen, is that the jury verdicts get paid and the appellate courts uphold the jury verdict. So that's much, much better, Like there was a 34 million with interest verdict. I think I've done videos about that. That was a fusion as well as a brain injury where a truck hit a car and there was like a kind of like a whiplash injury. And they paid the 34 million, which is crazy. In New York, they would never do that. In fact, in New York, there was $100 million verdict and that got knocked down by the appellate division to, I believe, 20 million. And that was such a horrific injury where someone fell from like a very tall height and had like this massive brain injury. And it was like one of the worst brain injuries, and all these like expenses, medical expenses, lost wages. And there was 100 million, but they said 20, and 20 was the most that's ever been sustained. Whereas, in California, like a more of a much more mild injury and 34, and it gets paid. So it's huge difference. And then Khalif says, how much are cases with radio frequency ablation and medial branch blocks have you settled them for? Yeah, I mean, I haven't had too many cases only with that. I've usually had like radio frequency ablation. I've had some branch blocks. Branch blocks by themselves don't really have too much value because what they're doing is they're going into those little nerves, the branch nerves. So you have the big nerves that are maybe running by the discs, right, and the vertebra, and then they branch off and you have these little branch. So if you need a branch block, it's a pain management procedure. I don't think it has too much value by itself, but in conjunction with other things. Whereas radio frequency ablation, what they're doing is they're kind of like burning the nerve because there's no way to, no safe way to fix it unless you're going to have like a full-blown fusion. So they just kind of burn the nerve so that the nerve doesn't give you pain. That's pretty serious. That's also pain management, but that's pretty serious. I would say radio frequency ablation, you could definitely do 6 figures, so over 100,000. We've had a few of those. But what I've usually had is those together with other procedures like a percutaneous discectomy, where the leak from the disc is removed with like a striker decompressor. So it's almost like a straw sucking out and removing the injury from the disc. So something like that, and then those we just had a verdict last week on one of those for 300,000. And then we had a bunch of settlements for like anywhere from 150 to, I think the biggest we ever got was like 550. So around in that ballpark. And then the machine says, good afternoon, Mr. Arkady. Slip and fall with third-party workers' comp combo with multiple surgeries and 1 million policy. What's my chance to get more than the policy going for 6.5-year wait? Well, to get more than the policy is going to be tough. You'd have to take a verdict for more, and then you'd either have to set them up for bad faith, which in New York is very hard to do. I think this is a New York case, right, from what I remember. Yeah, in New York, it's very hard to do. They really have bad or almost no bad faith law. So yeah, probably not more. I mean, you try to just get a settlement within the policy. 1 million is still a lot. So if you've had surgeries, try to just take the 1 million. Because to get more, I mean, you could go to trial and get more, right? The jury doesn't know how much the insurance is. Insurance can't be mentioned at all, right? So it's kind of like the elephant in the room, but you can't mention insurance. And so the jury can give you 5 million, 10 million, anything, right? They don't know that it's only 1 million, but then how is it going to ultimately get paid? So I would try to set them up for bad faith. I mean, that's probably the only shot you really have, unless you just take a bigger verdict and that person you're suing has some sort of asset. So the insurance will pay the 1 million and then the person will pay something on top if they have assets or money. But I wouldn't really worry about that. I would focus on trying to get the 1 million. 1 million, from what I remember, would still be an amazing result on a case like your case, basically, from what I remember. So. And then My Electronic Life says Johnny Depp defamation trial in Virginia was over a 10 million verdict. Oh, okay, yeah. But that's a little different, right? Because that's a defamation, that's a celebrity. I'm talking about more like, standard personal injury. But yeah, Johnny Depp, that was a. And then Sandy says, I'm being deposed next Monday. Any tips to crush it? Also, how soon is mediation after a deposition usually? Yeah, so I mean, I did a video where I gave some tips. I think it's called Super Depositions. And then there's also another video that I think we talked about last week because someone else found it and commented on it that this other video about depositions was really helpful for them. I didn't even remember that I did another video, but I just remembered Super Depositions. It's about a 40-minute video. I think the thumbnail has me in like a Superman or AI, whatever. and it's and it's called super depositions. And I kind of go through some of the outlines. So the outlines are basically some of the questions I've seen as a plaintiff attorney who defends depositions. So these are some of the questions that I see, and then how to best answer the questions. But ultimately, like, the easiest way to do it, the best way, is just to listen to the question, really try to understand what they're asking you, then answer it in your mind, without speaking, but in your mind, understand what they're asking you, understand how you want to answer it, and then, give that answer and make sure you're answering the question, especially if it's about like your background, medications, your past medical history, anything like that, right? If it's about liability, just, do that. Don't say too much, basically. So if they say, like, where were you looking right before you fell? Well, just think to yourself, where was I looking? From what best I could recall, I was looking straight and sometimes down, right? Because I'm not a penguin. I don't walk and always look down, and I'm not always looking straight and never looking down. So you just want to be like reasonable, So you just say, look, I was looking straight, but also, sometimes down. And that's it. Keep it simple. Now, where they ask you questions about your damages, right? Like, what are some of the things you cannot do? There, I would give like a bigger example, maybe tell some stories or moments in time, and really how it affected your life, what you can't do, what you can do, but not as well as you could before. Because the adjusters that ultimately are going to pay your settlement read those. And if you just say, I can't, go spear fishing, they're like, okay, well, who cares? People don't go spear fishing. So kind of like, you could do everything basically. But if you can't sit, you can't stand, you can't walk, you can't run, you can't cook, then there's like, oh, wow, this is really affecting this person. And then I would also get other people to say it, like friends, family, coworkers, neighbors, not just you. So you're not like the kind of like the malingerer or the, person who's just like complaining and whining, but you get other people to confirm it. Now, why would all these other people? You have like 5, 6 other people, maybe 10 other people. Why would all these other people who don't even know each other? One person is from your job, another person is from your, family, another person is your neighbor. Why would all these people be lying, right? Because remember, what they want to do is they want to say you're a liar, a cheater, and a fraud. That's what they want to do, the insurance company. So you have to do everything to show that you're not, that you're just like an honest, unfortunate injury victim, and you're looking for justice. So that's what it's all about. But good luck. Yeah, I think you should do well. And then My Electronic Life also says, Mr. Arkady, my lawyer waited 1 year after the ACDF to speak with my neurosurgeon. Why does it matter how I'm healing? The damage was clear. Well, no, it does matter. I mean, I don't know if he waited a year. But no, of course it matters how you're healing, right? Because remember, your damages are for the rest of your life. So I've talked about that before, like where we talk about the pattern jury instructions, and every state has their own jury instructions. And usually on average, people are living to like 83, 84 years old. So from now until then, right, on average, because nobody knows, right? You could live to 120, but some people, unfortunately pass away earlier, right? Whatever. So the point is that, it's always different, but they're going to go with averages, like statistical averages. And those are the pattern jury instructions. So let's say 84 years old and you're like 40. Well, you have, all those years, like 43 future years. So, so how you are doing, right? If the surgery didn't do very well, because they did an anterior cervical discectomy and fusion, they put in metal, they put in rods, possibly like screws into your vertebra. Now, like, it's known medically that if you've had that, you may need, at the level above, you may need another surgery in 15 or 20 years, and at the level below where they did it. So if they did it at C5, C6, well, you're going to need to do C7. You're going to need to do C4. That's 2 more surgeries. And then they may need to do revision surgeries. And there's just a lot. So that all goes to damages. That goes to future medical expenses. It goes to future pain and suffering. So that's really, really vital. And it goes to like your outcome, because it's known that some people don't have a good outcome after a fusion. A fusion is a really major, major surgery. So that's a good thing, I'd say, that he did that. And then Callie says, I was told today it's worth 40 to 65K. I feel like that was kind of low. I'm in Pennsylvania. Only 40K. Yeah, it does sound kind of low. I mean, but Pennsylvania, I guess maybe is a little bit more conservative than depending on like, what county you're in. But you could, if you're not happy with it, you could try to go to court and get more. But that's what I've seen. If it's only that without anything else, like I said, I've had that, but with other procedures like percutaneous or sometimes epidural injections, I haven't had too many I could think of off the top of my head, just like the RFA. But you could also do like a verdict search and see, or I could do one for you, like, or ask your lawyer and see what it's been in Pennsylvania. And Stomper says, hi, how long has this video been live? I just joined. Not too long, maybe like 15, 20 minutes. We just got started. And then My Electronic Life says, Mr. Arkady, my lawyer says juries like it when you try to go back to work and live your life, but I'm not completely healed after the ACDF. I thought it would look bad if I worked while injured. Well, no, I mean, it depends, right? Like jurors don't want you to be kind of like, if you can go back to work and if the doctor clears you to go back to work, but you're not working, then the defense can make an argument, well, this person is just like hoping for this lawsuit lottery, right? They don't want to work. They want to stay home and just like hang out. And now they're waiting for like a payday from these taxpayers. Because remember, most people like on the jury, they're working, right? They're just got to notice jury duty and they have to go back to their job in a few days when the trial is over. So the defense likes to make that kind of, I don't know if they want to say it outright or they want to make that insinuation, but they love to say stuff like that, right? Like, you guys are all going to have to work. I have to work. But this person, they just want like $1 million payday and they don't want to work. So, but if you can't work, if the doctor says like medically it's not safe for this person to work, they're so injured, then it's different, right? Because you can't work or you have to do a different kind of job. If you used to do like construction, but now you can only do a desk job. So it just depends on the facts and circumstances. But yeah, if you had a major surgery like that, that's not something you want to rush and go back to work. You want to wait until the doctor medically clears you. And then Anthony says, I don't understand why it's so hard to be able to see an attorney at your firm. At my firm, no, it should be pretty easy. Just text me like 347-566-9595, and we could set up like a call, a video call. We could do a in-person. We basically, have every which way it could be done. So yeah. And then Crystal says, is your family allowed to be with you during deposition? No, not family, unless they're in the case. Usually like a party to the case could be. So for example, like, in New York, I'm not sure how it is in other states. It might be different rules, but usually like, I mean, a lot of the times depositions are done through Zoom, right? So they could be like, nobody would know. They could be sitting somewhere in the room on the other side of the monitor. But I think technically it's not allowed, only the person being deposed and other parties to the case. So for example, if you're suing, but your husband is also a party to the case, they could be there because they're a party. But if they're not in the case in the caption, then usually they're not. That's the rule in New York. And then Mohammed says, hello, Mr. Arkady. I was rear-ended by a tractor trailer at slow speed collision and had 2 surgeries. One is a shoulder arthroscopic surgery and a cervical discectomy. Let me see. Okay. Yeah, that sounds pretty serious. I don't see if there's a question, but yeah, that's a pretty serious injury. Absolutely. It's best like if you text me, we could go over it and do like a free consultation and go in depth. But yeah, tractor trailer is usually, good because they have at least like 750, sometimes 1 million, sometimes more, like 1 million with excess. So it could be like 5 million, 3 million. 2 surgeries, arthroscopic and cervical discectomy. Those are both serious. So yeah, it should be a pretty serious case. And Chris says, I was more so just looking to see if you had any recommendations for my case or if I should stick it out with my current lawyers. I know it's been a while and it's complex, so I've been stumped. Oh, right, right. I remember. Yeah, that's the one we just recently did, right? The consult. Yeah, let me get back to you. Let's chat again, and maybe I could help you myself if you wanted me to, or I think it's a good case. Yeah, I'm not sure. That's the one where it was delayed, from what I recall, right? It was really delayed. Not much has been done, but it should kind of get fast tracked, and it should be a good case. And then James says, "Hi, how are you?" Kate says, "Car accident, 2 surgeries, under constant treatment. My lawyer ignored 18 months of medical updates. Defendant says it's degeneration, not accident. What's your view?" Um, you know, you'd have to be able to get your doctor to say, it's not really what the defense says, it's what your doctor says, right? Because the defense could say whatever they want. They always say degeneration, right? For everybody, not just for you. And their doctors are like hired guns. So their doctors, they call them independent medical exams, but they're not independent, right? If they were truly independent, then both sides would agree, hey, let's go to an independent doctor. Let's find a doctor. You know, they're independent. They don't know me. They don't know you. They're just a doctor. And let's show them medical records. Let's have this doctor examine the patient and let's see what they think, right? Like a neutral third party, kind of like a judge, but it's a doctor. But they don't do that, right? They call them independent, but they send your file and they send you to basically these doctors that they work with very, very closely, that they pay. And guess what? These doctors want more business from these defense firms and from these insurance companies. That's what they do. And a lot of these doctors, they don't even treat patients anymore. Their entire, you know, job, their livelihood is based on doing these exams. And if you look at their reports, it's like the same report. They just changed the name. They just literally, take out like Kate and put in John, and then take out John and put in Bob, and take out Bob and put in Susie. And it's the same thing. It's degenerative, blah, blah, blah. So, so the key thing, to combat that, first of all, you need a good trial lawyer to really cross-examine them and to get all the information from them, to like destroy them, to show that they're not fair and they're not impartial and they're not independent. But also what you want to do is have your treating doctors who did your surgeries talk about whether it's degenerative. Just, is it all a coincidence? Like, wait a minute, I had this car crash, really bad car crash, and I needed 2 surgeries after. So show a timeline of your like 10 or 20 years before the car crash. And were you also getting surgeries? Were you also getting treatment? Were you in pain? No, right? Probably you had no treatment. So show that like an empty timeline, and then show, boom, the crash. And then after, wait a minute, there's physical therapy, there's chiropractic, there's 2 surgeries, there's all this stuff. And you're saying it's just a coincidence. Like, this car crash did not cause all these medical appointments. Maybe there's hundreds of them. So yeah, so do that. And so basically, it's not good that your lawyer ignored 18 months of updates, but maybe they could get the medical records now and just fill it in. But yeah, it's not like, so basically what I'm trying to say is, get your doctors, the ones who did those 2 surgeries, to write like a narrative report for you, like a medical record, and to explain medically why it's not just the painless, normal aging process. It's not just a coincidence, but it's this crash that played a substantial factor in causing the need, the medical necessity for these surgeries, right? Then that's all you need. Now they have their guys, right? Their DME guys that are going to come in and say degeneration. You cross-examine them, and then you have your doctors who are not, they're just doctors, probably, that you found on your own, or whether the lawyer played a role, but it doesn't matter. They're probably just like treating doctors that do surgeries, and they're telling the truth, basically. So let that come out, and then it could be a big case depending on the types of surgeries. But that's a common thing, the degeneration defense. It's like every case almost has it. And then Larry says, "Hi, Mr. Arkady. I was injured in the Bronx when a police car was chasing a reckless driver. I had physical therapy, 4 epidural injections, and electroshock sessions. How much would my case be worth?" Yeah, so I mean, if a police car, the good thing there is you're suing the city, so there's no, there's no insurance cap, so the city is unlimited. The city's kind of slow though, so that's kind of a bad thing. How much it's worth? I mean, it's hard. It's hard to say if you can prove that the police did something wrong, right? Because if they're chasing kind of like a criminal, I mean, they still have to they can't be reckless, but if they had their lights and sirens on, they do get power, right? Power to like run red lights, power to chase a criminal. But with power, with great power comes great responsibility. So they still have to keep a lookout. They can't like run red lights and run people over. So, but it's a harder standard. It's not just a negligent standard, but it's a reckless standard. So you almost have to show that they were reckless. So that's going to be harder for you. But if you overcome that and you prove liability, then with 4 epidurals and electroshock, I'm not too familiar with, but 4 epidurals, I mean, it's probably worth. It's hard for me to say exactly, but I've settled like epidural cases for like the most I think is like 125,000, maybe no 100, maybe 140 something thousand. I think that's the most. But usually epidurals settle for less. They settle for like 20, 30, 40. So there's a range, I would say, from anywhere from 20, 30 all the way up to like 150 probably if it's just epidurals. The other thing, the electroshock, I'm not too familiar with, but also I would focus not just on the procedures, but also on the injury. Like, what were the epidurals for? Do you have a herniated disc? Is the herniated disc like affecting you? Is it preventing you from, living your life? Like, explaining that it's a life-changing, like forever injury, that it's really has an impact on you. That's more important. Whether you have lost wages, whether you have future medical costs, those are all critical things. And then Jen says, on average, what percent of drunk driving accidents end up in trial? I wouldn't know that. That's more like a statistic. You could probably look that up. You mean nationwide, or I wouldn't know. I mean, drunk driving, in general, I would say, like, from based on my experience, most cases don't go to trial. Most cases settle. So like maybe 95 or even 97% of cases settle. Probably only like 3 to 5% go to trial. I don't think it changes with drunk driving. Because the reason you would go to trial is because either they're offering you as a plaintiff, the reason you would go to trial as a plaintiff, as somebody suing, is because, look, they have a big policy like 20 million and they're just not being fair. This is a life-changing injury. I think it's worth like, say, 7 million, 10 million, and they're giving me like 100,000. So I have to go to trial. What else could I do? Right. That would be one of the reasons. And from a defense perspective, they might want to go to trial if you have really bad liability, which I don't think would apply, right? If it's a drunk driver, then you probably have good liability. They're drunk, they hit you. But that's usually, from the defense perspective, if they have good liability, basically if they think they can win, or they have this strong degeneration claim or whatever they have, or they think that you have a pre-existing injury and it's not from this incident, but you've had it before, the same injury, and they show an MRI from like a year before this crash. Hey, you have the same injury. What do you want from us? Kind of like, and they could paint you as this liar, cheater, and lawsuit lottery type person. Then that's what they want to do, right? So, but yeah, so that is kind of like probably the best answer I can give you. But you could probably look that up. I don't know if that people keep statistics on stuff like that. And then James says, I have a slip and fall case. I had arthroscopic surgery on my knee, but it didn't help. So I had a total knee replacement. Just curious, how much is my case worth? I go for deposition soon. Yeah. So, I mean, again, like the slip and fall, it would depend on what caused you to fall. What's the liability? Is it strong? Is it against a defendant with a lot of money, right? Because you could have a slip and fall against a homeowner, but the policy is only like 300,000. That's all they have. Or you could have a slip and fall against a big box store where they have like, unlimited coverage or like tens of millions of excess policies. And also, because slip and falls aren't easy. So sometimes you could have a slip and fall and you can prove liability, but a lot of times slip and falls get lost on liability because they're not easy cases. They could say, well, you should have watched where you were going, or you can't prove that this, whatever it was, like a puddle or a banana peel was there for any appreciable period of time. So if like a kid is drinking like a soda, spills a little soda, and a second later you fall. Well, they're not liable. They're like, well, we can't clean the aisle every second, right? It's impossible. So it just depends on all these factors. But the injury, I mean, yeah, total knee replacement, that could be worth, if the liability is there, that could be worth like over $1 million, I would say. That's a pretty serious injury, depending on where you are also. Okay, and then DND Dennis says, I fell through a floor at a hotel, dislocated my shoulder, had 3 surgeries, anchors put in, 94,000 in medical bills. The pre-suit offer topped at, let me see. I think I went too far and down with the, okay. The pre-suit offer topped at 275,000. We decided to file. Defense is now trying to blame an engineer. Does that change anything for my case? The Hartford is the carrier, 2 million policy. No, I think that's fine. I mean, yeah, I think that is kind of low. If you fell through the floor at a hotel and you have all these injuries like a surgery, anchors, that's probably worth more. If you have 100 in medical bills, I mean, then all these injuries. And the Hartford is a good carrier, the 2 million policy. I would try to get the full, I don't know if you get the full 2 million, but it's probably worth more than that with anchors. Probably like I've settled them for like 850. Maybe you can even get over $1 million. But yeah, I wouldn't, I mean, blame an engineer, but blame the engineer for what? Like that they didn't design the hotel properly? I mean, was it under construction, or what? Why would the floor just, break? Or was it like just you were staying at the hotel and you just fell through the floor? Or was it like some kind of construction? I'd have to know more, but it just basically, have your lawyer examine all that. Like if they have some kind of expert witness to say, hey, it was the engineer's fault, well, then you could just add the engineer to the case. You could sue the engineer as well. Or, have your own safety expert to say, look, this wasn't the engineer. This was the hotel. This was a maintenance issue. This was something they knew about. They should have fixed, but they didn't fix, whatever the cause of the floor collapsing like that would be. And then the hanger says, hello, have you ever defended anyone with prior convictions or multiple accidents, and how did either affect your case? Yeah, of course. I've done both. I've had a lot of people with prior convictions. I mean, prior convictions could be a little bit tougher depending on the jury. You have to, if it's going to go to trial, you have to, speak to the jury and make sure that they could be fair and they can still allow for significant compensation, even though the plaintiff has had prior convictions, depending on what the convictions are for. If it's something like, selling like drugs and they've done a lot of time, or like murder or something serious, people might not be able to set aside those beliefs and might think, what, I don't believe someone like that should receive compensation. So then you want to get those jurors off your jury. So prior convictions, depending on what it's for, could be a problem. You could also file a motion in limine to remove, some convictions or some, but sometimes they come in. And then you just have to basically speak to the jury and say, look, this person admits that they made a mistake, and you have to kind of like front it, just don't be quiet about it and let the defendants bring it up first, because then you look like you're trying to hide it. So you just have to like be open and be vulnerable and say, look, they made a mistake maybe 20 years ago when they were a young kid. They had whatever, drunk driving. They were, unfortunately, they got in with the wrong crowd. They did some drugs and they got convicted, and it's a felony. It's on their record. But, that was 20 years ago. They're a new person. Now they're married. They have kids. Would that, come into play? Would that factor into play? Like if you had this person who had that 20 years ago and you had another person who didn't, would one of these people get more compensation from you, right? Can you be completely and totally fair, basically? And if they say no, then again, you can get them off for cause. And if they say yes, but you don't like them, you can get, I think, 3 preemptories, at least in New York, meaning you can get them off for any reason, but you only have 3. So that's what I would do with prior convictions. Now, multiple accidents, again, it depends on how you, the evidence. Like if you have the same exact injury from before and there's like an MRI, like you have an L5S1 bulge, and then, you have the same bulge after this crash, well, they're going to say, what's the difference? You already had this injury, so we don't have to pay for it because you already had it. So if that's the case, that's going to be a problem. But if you had, let's say, a pre-existing condition, what you just have to say is that you weren't 100% healthy. But, most people, in society aren't 100% like perfect specimens of health, right? They're not Olympic athletes, they're not bodybuilders, they're just people, right? So everybody has some condition. So you take your plaintiff as you find him or her. So you have to talk about things like baselines and their ability to cope or deal with an injury. And so, like, for example, if somebody was completely healthy and never had any accidents, their baseline might be like a 9. So they get hit by a car. Okay, now they're at a 7 or a 6, but they're still okay. But if they already were like a 5 and they get hit by a car, now they're a 2. So it's kind of like they have less to give because they were this prior condition. So depends how you frame it, right? If you frame it the other way, wait, look, they were already vulnerable. They were already living their life, but some people live their life and they're vulnerable. What about an 83-year-old who's, walking with a cane or with a walker crossing the street really slowly, gets hit, falls over, hits his head on the concrete. Well, now he's got a brain bleed. He might need like 10 brain surgeries. Are you saying you're going to say, well, no, I shouldn't have hit an 80-year-old. I should have hit like a bodybuilder, like, Arnold Schwarzenegger in his prime when he was 25 years old. If I would have hit him, he would have said, you know what? Who cares? He wouldn't even fall from this kind of impact and just keep walking. So in that sense, nothing happens. And in this sense, I have to pay for 10 brain surgeries. It's like $10 million, right? But that's what it is. You take your plaintiff as you find him or her. It's just like you go into a store and you knock over a piece of plastic, nothing happens, but you knock over like a beautiful vase that's like $1 million vase. Well, now they're going to say, well, you broke it, you bought it, kind of thing. So, yeah. So with prior injuries, I don't really fear them. I just have like my own way of, and you'll see like a lot of the lawyers, other lawyers have written books about it. Like there's a book, Don't Eat the Bruises, by this lawyer Mitnick out of Florida. And I think he has another book, follow up to that, where he talks about these things like baselines, coping, and reserves, right? Your reserve is what you have left in your tank. So if your baseline was like, let's say a 9, then you become a 7, you're still okay. But if your baseline was a 5, well, now you're like a 1 or a 2 or a 1. Now you don't have much left to give. So kind of like this crash is what pushed you over the edge. And now, so that's if you frame it that way, then it's like, wait a minute, because he has a pre-existing condition, it's actually a legal protection. They're protected under the law because of the pre-existing condition. So because of the pre-existing condition, it's worth so much more because the damage is so immense, right? And now they're never going to recover. Now, basically, they have no reserve. You took everything from them. So it depends on how you frame it, right? If you frame it like the defendants want to frame it and the insurance companies, then, it's worthless. But if you frame it this way, maybe it's priceless, right? So that's just ways to think about it. And then Money Dog says, question, you were saying that there is a blood work test for TBI. Yeah, there is one. Yeah, I forget exactly. I think it's something with I forget. I have to look at my notes. Something with like a G. I think it's something with a G. But yeah, there's a blood test now that kind of shows whether there's a TBI. There's a lot of new research in TBI, a lot of cutting edge things. I'll review that. I'll review those notes and I'll do some more videos on TBI because I just found out today that I'm going to have another TBI trial probably November 5th. It was supposed to be sometime in October, but we got November 5th because it's also with the city. The city's always trying to delay, and they wrote us a long email. They wanted to try to get January, but good thing the judge didn't agree to January, and he gave us November 5th, which is only really like a month and a half away. So I have to start preparing for that. So I'm going to get a little busy, but I'll review everything. But yeah, there is a TBI blood test, absolutely. And then Stomper says, waited months to see if conservative treatment could heal my body, but nothing. And did the surgery, still in pain months post-surgery. Is that bad? One continues to be in pain after a failed surgery. I mean, yeah, obviously you don't want to be in pain. And also it's, makes your case worth more because the surgery didn't work. So now you have to go back to the doctors and see, do you need another surgery or what's the next step? So yeah, it makes the case worth more because you have more damage, but you don't want that in your life. You want to be healthy. You want to go back to living your life. And then second gear, says, hi, Arkady, wondering how eager judges are to move cases to closure. Defense just filed a third opposed motion for continuance. The case has been on the docket for over 3 years now. I mean, yeah, judges do want to move cases, but I guess it depends on their reason. If they have a good reason to ask for an adjournment, the judge may give it. But if there's not a good reason, the judge may say no. So it just kind of depends on that usually and where you are. Like in New York, like this case I had today, right? They were trying to get a continuance until January. The judge said no, which was like actually surprising because before the city gets so many favors from judges in New York, like they basically, just do whatever they want. And the judge is like, okay. So I thought we were going to definitely get January, but, we got a little lucky. I guess this judge kind of put his foot down. It's like, no, I told you October. Okay, I'll give you November. And it's like November 5th. So it's like real beginning of November. So, but it's probably good. I think probably we could get it prepped and then started, and hopefully they'll settle. Although who knows? It's the city, so maybe not. Maybe we'll have to go all the way. So we'll see. And then Sandy says, how soon after a deposition is a mediation usually set up? So a mediation could be set up at any time. It's basically when everybody agrees that the case should be mediated. A mediation is just like you show up, you talk about the case, the liability, the damages, you have a judge, but it's non-binding, meaning like you could just walk away. Like you could say, I want $1 million. They come in and they say, we'll give you 20,000. You're like, we're so far apart. Can you get closer to the million? I can come down, but I want like at least 850. They're like, no, are you crazy? All we have is 20. Maybe we'll give you 27.5. Okay, you're so far apart. Bye-bye. Let's just go home. We're wasting our time, right? So you could do that at any time. You could do it before the deposition, but usually there's no real usual. Mediations usually happen, I would say, when discovery is done. So not just depositions, but all discovery. But you could do them at any time, whenever you think it'll be fruitful. But I don't like to do mediations unless you get a good faith offer. So if you're trying to get, let's say, $1 million, you get an offer for like 300. Yeah, sure. Even 200, go and do the mediation. But if you're trying to get, like, say, $1 million and they're not willing to give you any offer, don't do the mediation, because all they're going to do is just like lowball you and basically tell you your case sucks. So why pay money for that and waste your time for that? Okay, and then Stomper says, I passed my IME from no fault, even many months after the crash. I'm in deep pain and does the defense acknowledge I passed the IME for my no fault, or does that not matter? I'm not sure what you mean by passed. Like passed? I'm not sure. I mean, an IME is basically for no fault. If they give you a no fault IME, then what they're basically saying is whether or not you need more treatment. So if they deny you, then basically they're saying that you don't need more treatment. Is that what you mean by passed? Like you passed, they said you were good medically, that they denied future medical treatment, but that's bad for you because you want future medical treatment, right? You're hurt, you need future care. And if they deny you, they cut you off, then you can't get it. That's usually how no fault works. But I'm not sure about this phrase that you use, pass. It's not like a test, like you pass or fail. But so I'm just not sure about that. But if that's what you mean, then, that's usually what they do. They usually deny or cut you off. They usually say that you're better and that you don't need any more treatment. You could still get treatment. You just have to do it on a lien or use your health insurance. You just can't use no fault. But no fault isn't going to be there for the rest of your life. No fault usually is there for like the first 6-9 months after an accident. Then it kind of, whittles away. That's usually what happens for everybody. And then My Electronic says, Mr. Arkady, in a depot, can defense attorney grill you about old injuries or claims 5 to 10 years? I had ACDF, but can they grill me about a slip and fall injury, for example? Well, yeah, if you had a slip and fall, they could ask you about it. I don't know what you mean by grill. I mean, don't think they're going to grill you, right? Don't have that kind of mentality, because then you're already coming into the deposition thinking, oh, they're going to grill me. I have to be like, adversarial towards them. And then you might say something that you'll regret, and then they'll use that against you later, right? Because you're very like confrontational with them. Just, they can ask you questions. Just be calm, be chill, go in there and just listen to the question. Have you ever had a slip and fall? If you know you did, just say yes. Okay, and what was your injury? You say 10 years ago. I don't remember. I could try to find my medical records. Remember, medical records are only kept like 7 years. So if it happened 10 years ago, they might not exist. So basically say, look, I slipped and fell. I hurt my leg. I don't remember. And they can't even get the medical records now. They have no proof. So who cares that you had one, right? So it only really hurts you if they have actual medical records that show that you have the exact same injury that you have now, and that you're basically claiming, but it's not, because you had an ACDF. Obviously, you did not have an ACDF for that slip and fall 5 or 10 years ago, right? So, and even if you had, let's say, a herniated disc in the same area, but you could say, look, I had the herniation, but I was living with it, and I was pain free, and I was living my best life. I was going to work. I was doing everything. I didn't need ACDF. But guess what? After this incident, right? Now that pushed me over the edge. Now I need the ACDF. So that's an aggravation of a pre-existing condition. So yeah, so that's their fault. That's just like what we were talking about earlier with the prior accidents and all the reserves and baselines and coping. So yeah, so I wouldn't really worry about that. But I would just like frame it, try to don't think of it as I'm going in there, they're going to grill me, because then you're going to maybe get mad and say something, and then they could either video record you or even have the transcript, and then they could later read that to a jury, and that could turn a jury off. So I think the main thing with depositions is, just like I was saying, listen to the question, be totally calm, be professional, be nice, present. Don't think that you're talking to the defense lawyer. Even the defense lawyer is the biggest a-hole in the world. Think like you're talking to a jury, right? And you have in New York, it's 6 people in a jury. In other places, it's 12. But think that you're talking to this jury of 12 people, and they're all very nice. They're all there to help you, and they want to give you fair compensation for your injuries. But how do you want to present to them? You don't want to be angry and yelling and or hiding things. You want to be your best self with them, and then they will give you that compensation. So that's the way you have to think of it. Okay. And then Stomper says, love this live video idea. You're an innovator, sir. Oh, thank you so much. Thank you. That's really cool. Yeah. I'm going to do a few more lives, maybe some different ones. I know we did one live, I think, before, or one or two, where people actually wrote in a little bit about their cases, and I was able to maybe research live on the verdict search. So we could try one of those again. If people think that's a good idea, then I could actually, go to your town. Like if you're in Miami, we'd go to Miami, and if you have an ACDF, we could look, hey, what are ACDFs worth in Miami? We could look at some of the cases and, answer that for you. That could be helpful. And Chris says, yep, that's me. Oh, okay, thanks. Yeah, I'd be honored to have your help if you were up for it. Been a fan of the channel for years, so I wouldn't blink an eye at the opportunity. Oh, thank you so much. Yeah, let me take another look. I think I should be able to help you with that, because I remember it was a pretty straightforward and pretty, serious injury. So I just don't like to see it linger like that. So yeah, I would be happy to help. And Lisa says, good day, Arkady. Hi, how are you? And Anthony says something about the firm. I'm not sure what Anthony is asking, but yeah, just like I said, just text me. It's 347. I usually get back to everybody the same day, 566-9595. So it shouldn't be hard. I just you just text me, and I'll set everything up, a call, whatever you wanted to do. Stomper says, does the amount of anchors in an arthroscopic shoulder surgery influence how serious and valuable the injury is? Will one anchor be considered as valuable as 2 in a venue like Queens? Well, I mean, what it is, it just depends, right? It's not just that. I mean, of course, if you have anchors, that's more serious than if you don't. If you have 2, that's more serious than if you have 1. But it's kind of it's not an exact science where you could say, well, I had 2, so I should get 600,000, but you had 1, so you get 400,000. It's the overall picture that you're able to paint. So it's how you do at a deposition, what's the liability, how much insurance do they have, and the overall damage to your life. If you explain that you can't pick up your child, or you had something that you wanted to do, a certain profession, maybe you wanted to become, I don't know, a firefighter, and you wanted to help people. Now you can't because of this injury, right? The jury might really like you and give you more, millions of dollars, right? But if you are somebody is whining and complaining, and they're oh, I can't do this, I can't do that, but the jury doesn't believe and says, yes, you can. My brother had the same thing, and he went back to work. They don't like you for whatever reason. They can give you a lot less. So it's kind of like art, right? Art, you might like a Picasso. Someone else might say Monet is the best painter. It's not an exact science. It's not you had 2.3 anchors, so you get this, but you had 1.7 anchors, so you get, you know what I mean? So it's not mathematical like that. But of course, I mean, I'm not going to say that a 1-level fusion I mean, in the right hands, right? One lawyer could try a 1-level fusion and get 9 million, and then another lawyer could try a 5-level fusion, which is much worse than a 1-level, and get like 500,000, just because maybe the lawyer's not likable, maybe the client's not likable, whatever. It could be liability issues. So it's not an exact science like that, but generally, yeah, the more procedures you have, the more it's worth. And then Lisa says, I've had 17 surgeries in 2 years and 3 months. I was broken from head to toe. Oh, I'm sorry to hear that. That's terrible. No, you don't want to have that many surgeries. And then My Electronic Life says, Mr. Arkady, I heard an EMG test is hit or miss if you have radiculopathy, but the EMG shows nothing. Can that hurt your case? Why do the EMG? Well, no, the EMG is actually, from what I've seen, it's helpful because it shows the actual waves, and it's like you can't fake an EMG, right? So they're actually showing the fibrillation potentials. So it's like electric myography, and there's also NCV, nerve conduction velocity. So they hook up these little, pads to you, and they're seeing whether, because if you have, let's say, a herniated disc, right, in your neck, that could be traveling, and that's called radiculopathy, right? Where you have the traveling pain to your arms. And if you have it in the lower back, it's traveling to the leg. So they're basically testing to make sure that that's really there, the radiculopathy. So if it's confirmed by EMG, it's a great argument for you. You could say, look, it's not just, it's on the MRI that I have this herniated disc. I'm feeling radiating pain, but it's not just me saying that I feel it, like faking. It's on the electric, myography, EMG. You can't fake that. And they actually, there's sounds you could listen to, fibrillation potentials, and there's like electric waves. So I've actually used that to my advantage, and you could increase the value of the case. I haven't heard really that people that do have radiculopathy come up normal on an EMG. Now, if you do take it and it's normal, then just don't mention it. I mean, the defense could maybe mention it, but yeah, but basically, I wouldn't really like not take it. I think it's helpful. Every time I've had it, the people have been finding finding a radiculopathy. And maybe a few times it's been normal, but like I think you're the person who mentioned you had a fusion, right? So I'm thinking if you had a fusion, it's probably a serious injury. So the EMG should be positive. I've only seen it normal, like in a few cases where it was like really mild injuries. I haven't seen it normal too often, but that's just been my experience. I'm not a doctor, so I'm not sure exactly, but yeah. But like I said, I wouldn't like not do it. I think it's very helpful if it's positive. And then Second Gear says, at what point in a case does a mediation take place? Well, like I said before, like anytime. You could do a mediation anytime. Trial and pretrial date is set for October. The case has been ongoing for 3 years, but we have not had a single mediation. Major back injury with TBI. Well, you don't have to have a mediation. Remember, a mediation, unless it's court ordered, right? If it's court ordered, then you do, because it's court ordered. But basically, a mediation is just a chance to settle. It's like a settlement conference. It's basically like your lawyer says, well, I want to go to a mediation, and I like Judge A. And then the defendant says, okay, I'll go to a mediation, and I like Judge B. And either they agree on either A or B, or they agree on another judge like C that they both agree to. So the judge is there. You do a mediation package where you talk about, here's the liability, here's what happened, here's how much insurance there is, here are my damages, my medical records, and you submit it to the judge. Then you show up, and you basically start talking turkey to try to settle. You say, I want $1 million. They say, I'll give you, 100,000, and you see if you could bridge the gap and come to a settlement. If you can, you do. If you can't, you say, okay, we tried, and you just walk away. It's not binding. Nothing happens. There's no, it's just basically like, the judge just facilitates a chance to try to settle the case. But usually, everyone takes it seriously because they're paying the judge like whatever, $500 every hour, right? So it's like everyone takes it seriously. They're not saying that they're not just coming in there. But what I do see a lot is that the insurance companies, agree to the mediation, and they just come in and then they lowball and they just don't offer enough. And then they talk about how bad your case is. And they love to do that because they love to then kind of like throw this disillusionment because, these injury victims, a lot of injury victims are thinking, I got a mediation. Okay, I'm going to show up. I'm going to get $1 million. It's not that easy. They show up hoping to get some big amount at the mediation, like thinking the mediation is the end of the road, like the pot of gold right at the end of the rainbow. But when they show up, the defense lawyers and the insurance adjusters that are actually paying the money, they know this, right? So what they do is they show up and they say, look, this case is terrible. We're never going to pay anything. And kind of like to then breed a certain type of, disenchantment or, kind of put a stick between the plaintiff and his or her lawyer, because then they're going to say, look, why did then you're going to look at your lawyer, right? If you're the injured party, like, why did you even bring me here? Like, if they're just giving me 20,000 and we talked about this case is worth $1 million, why did you even bring me here? Because, the assumption is that insurance companies are going to be fair. The people think that, sometimes lawyers think that, plaintiff lawyers. And, sometimes that's a bad assumption. That's why I like to get a good faith offer before going to the mediation. So if I'm trying to settle a case for $1 million, like I said before, they give me 200,000. Well, that's something, I can go to the mediation and I could see, well, how far could I get them to the $1 million? Can I get them to 600? Do I get them to 700? And then at that point, maybe my client wants to take it and we settle it. But if they're, but what's the worst that could happen, right? But if they're at zero, that, there's nothing magical that happens at a mediation. Like unicorns don't fly from the sky, nothing magical that happens at a mediation. So it's like, if the mediation is scheduled, let's say for December 5th, right? Or any date in the future, December 5th, let's say, just for example, the mediation is December 5th. Well, why can't the adjuster, get authority and call me or send me an email and give me an offer like today or within the next 7 days? Like, what's magically going to happen on December 5th in that room with that judge that they're going to give me $1 million that they can't give me like 200,000 or 300,000 today? And the answer is nothing, right? You don't even have to do a mediation. You just pick up the phone and be like, I want $1 million. Are you going to give it to me? Yes. Okay. Thank you. Bye. Like I send letters sometimes, the settlement opportunity letters, and I say right in the letter, you have 30 days. It's a long letter. It's like 15 pages. It has all the injuries, all the liability. And I say, look, here's a deep dive analysis of all the medicals, all the, human story, biography, liability. Pay me, $1 million. You have 30 days. You have until, let's say, October 9th, 2025 at 5 p.m. At 5:01, you don't have to pay me the $1 million. I even say sometimes pay me the $1 million or give me a good faith offer against it. Because if they give me like 850, maybe my client would take it. But then I also say in the letter, but if you let it expire, then at October 9th at 5:01 p.m. in 30 days, it's not going to be $1 million anymore. And you don't have to give me the $1 million. You could say, no, that's fine. But then it'll be like $2 million. And the more I spend preparing for trial, the more it's going to increase. So I'm doing the opposite. See, what they want to do is they want you to demand, kind of like low. You demand high. They're going to say, are you crazy? You're asking for all this money. And they want to drag you down into the deep dungeon and give you as little as possible. But what I'm doing is I'm flipping the script on them. I'm saying, look, pay me the $1 million. If you don't, that's fine. I love going to trial. I'll go to trial. But then it's not going to be $1 million anymore. It'll be 1.5. It'll be 2. It'll be 2.5. And it's like, well, they're like, oh, they don't like that because they like to control their risk. They like to pay as little as possible. And this actually increases their risk. They're like, oh, wait a minute, and I found that a lot of cases settle like that, like a lot of cases. In fact, like the last case I did a trial in the Bronx. It was a traumatic brain injury, but it was a mild one. And we got 3.1 million. And I think that letter really helped because I had a comprehensive letter. I explained like why we had the life care plan, we have the future medicals, we had the lost wages, whatever, all the categories, pain and suffering, future pain and suffering. And I said, look, even conservatively, it's like, I think I was like, according to my numbers, even conservatively, it was like 4 point or 5.5 million. And then, and I was basically saying, look, what are you talking about? Because at one point they were only offering 140,000 and they were saying we should take it. And that's all the case was worth. But because I had this letter and I kept going up, at one point the lawyer got upset because she was like, oh my God, now you're saying you wouldn't even take the 5 million. Now you're at 7 million. But then they offered 3.1 and then the client wanted to take it. But that's how we got to the 3 by sticking to our guns and going, being ready for trial. We were about to start the trial. We were there for jury selection. We had everything done. that's the only way you could do it, really. Okay. And then Lisa says, do you trust the CIA? I don't really know. I don't really have too much interactions with them. Let me see. Let me try to get through a few more questions here. Oh, because we're already over an hour. Well, that's good. We have so many people interested in this. We have all these engagements. So thank you for that. I really appreciate that. Let me try to get through these questions quickly. Jen says, I suffered a transverse C7 fracture, mild TBI, and PCS from a drunk driver driving a company truck, not a semi. Company's insurance accepted 100% fault. My lawyer is going for limits, but I do not have not been told limits. What do you think my case may be worth? Well, yeah, I mean, if you have a fracture like that and a TBI, depending on where you are and things like that, it could be worth the policy. If it's $1 million, it could be worth $1 million. I mean, a TBI, I think a TBI is always worth like millions because a TBI is really serious. There's no such thing as a mild TBI. And they got rid of that word mild. It's like being a little bit pregnant, right? It's like you have a brain injury. It's not mild. It's never mild. So I wouldn't really categorize it like that because they got rid of that. That's no longer in the definition. The definition, the word mild is gone. So if you look at the 2024, 2025 updated definitions. So yeah, I mean, that's the big thing. But the lawyer has to be a trial lawyer. They have to know how to prove a TBI. That's the critical thing. And also, yeah, the transverse C7 fracture, that's serious too. I had one of those fractured without surgery cases, and I think I got like 450 on it against Geico. So you could do pretty well with that. And they accepted liability. Well, it's just damages only. So that sounds like a good case. If you need any, consultation, just text me 347-566-9595. Let me see what other questions we have. Oh, she says, or Jen also says, I recently got done with physical therapy where they did dry needling, electrotherapy. Now I'm in speech therapy. Oh, so that's pretty serious. Oh, for the PCS. What does PCS stand for? Maybe I'm not getting it right now. But that's post-concussion syndrome, right? That's what you mean? Oh, so that's serious. You have speech therapy and you have post-concussion syndrome. So that's a legitimate TBI. You wouldn't be in speech therapy if you didn't have a legitimate TBI. Oh, yeah. So that's worth way more. That could be worth many millions. Find out how much insurance they have. That could be worth like 5 million or more, depending on where you are. And there's also a follow-up MRI for the white matter issue from the TBI in December. Yeah, so that's a great case. That should be a big case. Just make sure you have a real trial lawyer. If you want, text me privately. I could run a verdict search on the lawyer and send you the results like to your email. Because some people, claim they're like brain injury lawyers. They've never tried a brain injury case. Or sometimes, it just is what it is. Like sometimes people tell me I have this lawyer and I do a verdict search and they're good. They have like, 7 million, whatever, 5 million. But sometimes people say I have this lawyer. They say they're great. They put on their website, they won like whatever, 100 million. And then you do the verdict search and they're like 0, 0, 0, 0, 20,000, 0, 0, 0, 4,000. And it's like, wait a minute, that's a red flag, So it is what it is kind of thing. You never know until you check. And then Stomper says, weird question. What if one was arrested for the very first time during their personal injury case for damaging their wife's phone, but the charges were dropped and no conviction? Pain makes me cranky. No, that wouldn't matter. If there's no conviction, it wouldn't come in. So it wouldn't matter. It would be excluded. It wouldn't come in as evidence. See what other questions. Kenzie says, I slipped and fell on wet floor in Stop and Shop in Queens. I had shoulder and ankle arthroscopy, ankle fusion. Yeah, that's a good case. That's a good case. Yeah, we'll get that case worked up and get it, get the maximum on that. Well, ankle fusion should be really big. And then David says, how much do you think RFA with PTSD settlement value would be? Well, RFA, I think we talked about, right? Like by itself, probably like, 50 to 100. PTSD, if it's legit, if it's real PTSD and you have the treatment, it could be big. It could be like anywhere from a few 100,000 even to $1 million. But it's hard to give numbers based on very short, PTSD. Like one person's PTSD could be worth zero, another person's PTSD. I mean, there's one lawyer who goes and does these PTSD cases, and they're real serious PTSD, and he builds them up, and he gets like, I think he had one case where he got like 100 million or 75 million, some crazy numbers. So it's like it really runs the gamut. You'd have to look at the file and examine it in depth. You couldn't just say every PTSD is worth X. It's not like that. And then My Electronics says the defense hires a defense attorney before a lawsuit is filed and their attorney wants mediation. Is that a good sign? Why would they waste money on an attorney so soon? Oh, you mean they want a mediation before you even filed a lawsuit? I mean, yeah, but they're probably going to lowball you. If you have the ACDF, you probably I think you're the one with the ACDF, right? So you probably want to file a lawsuit if you have ACDF. You get full value. Let me see. Brandon says type 2 diabetic, kidney hospitalization, skin infection on the foot. Could this be worth? I'm not sure. I'd have to look at the medical records. That sounds like some kind of like maybe medical malpractice case or medical case. It's hard to say off a YouTube comment. I'd have to read the medical records or get them reviewed. Usually what I do is I get the medical records, I send it to a doctor. The doctor reviews it and the doctor gives me his or her opinion. And then based on that, if the doctor says there's a mistake and the mistake caused an injury, then I take the case, as a medical malpractice. But if the doctor says no, then you can't just take a case without a doctor reviewing it. And then L Boogie says, hey, I have a case that I have surgery, but bilateral shoulders, bilateral knees, and a lower back surgery and microdiscectomy on my L5, L4, L3, S1, and S2. Oh, that's pretty serious. Yeah, with surgery. That should be a good case. And Lisa says she's still waiting on 3 surgeries. I'm sorry to hear that. And Kate says, is it possible to arrange a video consultation with you? Could you please let me know how I can book it and what the procedure is? Yeah, if you just text me, 347-566-9595. I just ask usually people when they text me, just tell me your name, your city, your phone number. Well, I guess I'll have your phone number if you text me. Just give me your name, the facts of what happened, just briefly, so I could almost see it happening. But it doesn't have to be long. It could be like I slipped and fell on a puddle in a store, or I was driving, I stopped at a red light, I got rear-ended, something simple like that. And then tell me your injuries if you know them, like I have, like people have been doing here, ACDF, or I have a, torn labrum, or if you don't know if it just happened like yesterday, I have pain in my neck, whatever, just a little summary. And then I could schedule a call. If you want to do a video call, we could use Zoom or, Google Chat or video. If you wanted to just do a regular call, whatever you prefer. Sometimes, like I was saying, we could record the consultation and even post it as a video, but we edit out anything confidential. So it's just general questions like, what's my liability? What's my, how I would handle this situation. And then Cash Scratch says, I'm in Georgia. My case is going on 2 years. The max insurance payout is $50,000. Bills are $40,000. Insurance company is sticking firm and not wanting to pay the max. Yeah, well, I mean, they're always trying to save their money. Unfortunately, they're being unfair. But yeah, if it's only $50,000, that's all they have. That you should write them a bad faith letter, like I was saying. Let's say pay the 50. If you don't, that's fine. But then when I go to trial, I'm going to tell the jury it's worth 500. And if they return a verdict of 500, what are you going to do? Now you're leaving your policyholder, they're insured, out to exposure, because basically in Georgia, I believe there is bad faith law. So if you hit for 500,000, then who's going to pay the other 450? It's going to be this policyholder, but they have a duty of good faith and fair dealing to their policyholder. They can't just expose their policyholders to such danger. So I would have your lawyer write that kind of letter. And then B, the Lightkeeper says slip and fall, complete avulsion of hamstring, 62 on disability, had 2 surgeries, L2, L3, extreme lateral interbody fusion, car wash chain slipped in the puddle with mud while reaching up to grab a vacuum hose. Oh, I'm sorry to hear that. That sounds like a really good case, because yeah, those are serious injuries. And also it sounds like, yeah, if the car wash chain slipped in a puddle, and the puddle had mud, it sounds like it's their fault. So that sounds like a good case. And then Rob says, I have a case, Iowa personal injury accident. The insurance company's lawyers 2 weeks before trial to delay for 4 months. Why do you think they're doing this? Well, they always try to delay, because if they delay, they don't have to pay you, right? So they always try to delay, but I would oppose it. Don't let them delay. And unless you want to wait 4 more months, I just would oppose it. Let the judge decide. And then B, the Lightkeeper says, first surgery, 4 months in home physical therapy. Let me see, because scrolls down too fast. Oh, first surgery, 4 months in physical therapy, non-weight bearing, plate screws in both surgeries. I can't find anything on approximate settlement values. Oh yeah, just text me 347-566-9595. I could run a search and see what the settlements are in Missouri for something similar like that. And then Duke Boy says, I got rear-ended, have herniated discs, multiple, have 2 back surgeries. I already have had epidural, hasn't helped, been in extreme pain, located in Oklahoma. Geico Insurance was the insurance. Yeah, that sounds like a good case. I mean, if you had 2 back surgeries from it, as long as there's enough insurance, that could be a big, big case too. Epidural is pretty serious. So yeah, I mean, that's a good case. Rear end cases are always good because it's not your fault. So it's just a matter of how much insurance they have. And then Reese says, rear-ended by a company car, 2-level neck, disc replacement, rotator cuff, bolt shoulders, TBI, out of work for a year. Oh, that's really serious too. So those are serious cases. Yeah, it just depends on where you are. I would try to get policy limits on both. Just get everything. So yeah, I mean, if you out of work for that much time, you're going to have lost wages. Or he says you're in Brooklyn too. And Brooklyn is a good venue. So 2-level disc replacement, that's serious. Just find out how much the company car has in insurance. Make sure you have a real trial lawyer handling it. If you want, I could do a verdict search and send you the results privately. Just text me 347-566-9595. 2-level, yeah, that's real serious. And then you had both shoulders, TBI. TBI is depending what you have. If it's a real TBI and you have enough treatment with all the neuroradiology, neuropsychology, and you have the of course, the neurologist. If you have a lot of treatment for the TBI and you have the goods basically on the TBI, that could be huge. That could be a big, big case. Company car, if they have, let's say, $1 million with like a $3 million excess, that could be worth the full $4 million, or maybe they have more. And William says, Arkady is the best. Oh, thank you, William. Why would arthroscopic shoulder surgery and percutaneous discectomy with a $3 million policy? What is it worth in Queens? Queens isn't the best. I mean, you have to really spend time picking a jury because you get so many different people in Queens. Some of them may not like, these types of cases, but arthroscopic with the perc disc, I mean, I've been settling them arthroscopic for like, 200, 250 perc discs. I was saying earlier, I've been settling anywhere from like 150 to 550, I think was the highest. If you have both, you would get maybe like, say, 200 for the scope and then another 200, maybe 250 for the perk. So I would maybe like 300 to 400, I would say, maybe a little more, 500. And then Duke says, I even had developed stomach ulcers, been in the ER twice. How much do you think the value is? Does it depend only on the coverage? The person drove a BMW. Well, not only on the coverage, but you want to find out how much coverage they have, because it might be hard to get more than they have, right? So if they have, let's say, 250, well, actually, if they have 250, they could have $1 million in umbrella. So find that out. But yeah, if you're going to have 2 back surgeries, that you should get whatever the coverage is. If it's $1 million, you'll get the $1 million. If it's more, you'll get more. But if it's really small, like 25,000, well, then, it is what it is kind of thing. But you could try to also bad faith them, or if it's small, like 50, you could say, pay me the 50 because look, I'm going to need 2 back surgeries. And if they don't, then you could argue the policy is open. I don't know if Oklahoma has strong bad faith law, but you could ask your lawyer about that. Let me see. And then Kate says, after a car accident, C6 fracture, scapula fracture with 2 surgeries, multi-injury, treatment for 5 years, and still suffer constant pain. No, I'm sorry to hear that. That's really serious. That's all very, very horrific injuries. And then KCV says, will a settlement offer go down if a new medication significantly improves your symptoms? Now you have to rely on meds the rest of your life to not be in pain or lessen the TBI symptoms. I mean, I've never really heard of that. I don't think it should really go down. I mean, they could make that argument that, before you would have to live with pain, but now this medication is going to make you feel a lot better. But I've never really heard of a settlement offer going down because of that. And then Duke says, I've been on disability for pain. Does it make my case worth more as well? Sorry for all the comments, just needing some info. Yeah, of course. If you're on disability and you can't work, then you get lost wages. But plus, the more you have this injury, the more future pain and suffering you have. Past pain and suffering. Past meaning from the date of the crash up until the trial. Future meaning from the date of the trial for the rest of your life. And like I was saying earlier, people live to be like 84, 83 on average. So there's a lot of possibilities there. Also, medical costs, right? Because if you have all these procedures like 2 surgeries, the future medical costs, there's adjacent level disease. So if you have the surgery at one level, the level above, level below, you're going to need those 2 surgeries. So that's future medical costs, and those get extrapolated. But it's not just the surgery. There's physical therapy, there's prescriptions, there's MRIs. And remember, it's not just once. You're going to need it like for the rest of your life. So just the medical costs could be like I had a case, it was like 2.8 million in medical costs, and he had a 1 surgery. So if you have 2 surgeries, it could be more than that. It could be, you have to have a doctor and an economist calculate all that. And then Williams says, Queens, New York, shoulder surgery, arthroscopic and percutaneous discectomy of the neck. What is it worth on a 3 million policy? I mean, it's hard to say exactly, but yeah, shoulder surgery, arthroscopic, like I was saying, about 300, 200, percutaneous also probably 200-300. So maybe like 500, maybe a little more, depending on who's handling it. If they're a trial lawyer, if they're willing to go to trial and push for more, or whether, because a lot of the times, if you just try to settle it, they're going to give you something, right? They might give you 175. So a lot of lawyers will say 175, that's great, take it, but if you have a real trial lawyer, they could prep it for trial, go pick a jury, and then say, look, I don't want 175. I want like 1.2. And then by doing that, by having the jury in the box, by, starting the trial, maybe doing opening statements, they're really kind of pushing the needle. Now, I don't know if you want to go all the way and risk it and take a verdict. That's one thing you can do. Or during the trial, that's when they really start coming up, and they're like not at 175 anymore. Now they're at 350. Now they're at 550. And then you could settle it during trial for like maybe 750, just an example. But, you have to, it depends on who's handling it also. And then Israel says, what's the best way to talk about damages after liability is established? I'm not really sure what you mean. You mean like the best way? So you've proven liability. Usually, I mean, if you're on trial, you just have to talk about everything all together because it's a trial. Or if it's bifurcated, then if you win liability, then you have a separate damages trial after. So you do opening statements for like liability, you win liability, you get maybe like, the same jury, sometimes a different jury. And then usually it's the same jury, I think. And then you have another trial only on damages. So that's the best way to, but if you mean like, I'm not sure what you mean by talk about it. You just have to prove it the same way that you prove liability. It's just, there's many different things that you could do. There's like the human story, there's medical records, there's experts. So, that you just prove damages. And then Miguel says, hello, Arkady, to put a case on the waiting list to see the judge, it can be done in the process of discovery. Usually after you file a note of issue, it goes on the trial calendar. And then Yes says Penske was added in a lawsuit by judge and compliance order. If truck was leased or rented, do they carry additional insurance on top of the 1 million? Well, you have to ask them. Sometimes they do. Sometimes, they may not. There's certain things with leases too. There's like the Graves Amendment where they have less insurance just because they're a leasing company. If that's all they do, they could say we're not We just have the minimum coverage. So there's a lot of different things at play. So you just have to find out through your lawyer. I wouldn't be able to tell you that, that's specific to your case, how much insurance they have. And then Tony says, if you have a lot, very solid, strong evidence, is it good to wait 2 years for going to a lawsuit in personal injury? Well, if you have the evidence, I would file the lawsuit as soon as possible. Because remember, the lawsuit itself takes a lot of time. So, I don't know where you are, but in New York, like the lawsuit, could take like, even after you file it, just to get to a trial could take like 5 years. In the Bronx, sometimes it takes like 8. It's crazy. So why would you want to wait 2 years on top of that? You know what I mean? I would just file it as soon as possible. If you get additional treatment, you just supplement the bill of particulars, you do another deposition or whatever you have to do. But I would file it as soon as possible, especially if you're in New York. Some places, maybe if they move super fast, it's better to finish your treatment, and then once you've finished your treatment to do everything else. But I guess it just depends. And then William says, my doctor recommended a fusion, and I already had shoulder surgery plus the percutaneous discectomy. Going to mediation, they offered $350K. Mediation is in January. Is that normal? Yeah, of course. Yeah, mediation. Usually they don't give you mediation right away. Yeah, because everyone's busy, and the mediators. A lot of times the mediators are busy because they have so many cases, so you can't get a date. And now is like settlement season, like September, October, November, December. That's called like settlement season because it's the end of the year, and the insurance companies want to like pay out on claims to like write it off their taxes. So it's kind of known as settlement season. So yeah, they might not have anything until January. So that's pretty normal. Oh yeah, NAM. Yeah, I've done mediations with NAM. Yeah, absolutely. So that's fine. So yeah, I mean, if you have a fusion recommendation, then it could be worth much more because that's a major surgery. Even if you're not going to have it, you could say, even if you're not going to have it before January, you could say, but I medically need it, so I may have it like in the next 6 months or before trial, and then you could push them, and then they try to get like into the millions. Okay, I think that's good. I think we answered a bunch of questions today. We've been at it almost an hour and a half. That's good. Wow. Okay, everyone. So please like and subscribe to our channel. Let us know what questions you have. We are here for you. Our goal is helping serious injury victims and families. And all the best to everyone. Oh, and William says, what can we do for you? Well, just please like and subscribe to our channel. We do have in the description, if we've given you a consultation, you could leave us a review. That always helps. You could click the link. I think it says leave a review in the description. That always helps to get a review, because then people who need a lawyer, maybe in Brooklyn, the Bronx, here in New York City, could find us and would become more prominent the more reviews we have. But other than that, we're going to continue. I'm going to have a lot of more videos. So I'm going to do videos about verdicts, videos about the legal process, and let me know, give me ideas for videos, because I feel like I've done a lot of videos already. Maybe even, I forget how many, maybe even like 500 or something, a lot. So maybe what we could do is we could come up with some new ideas, but I don't want to do videos that the audience is not interested in. So let us know what videos you want to see, and I'll do videos about that, whether it's the legal process, whether it's mediations, whether it's depositions, whether it's trial, whatever you guys want to see. I know people are asking verdict searches, so I'm going to do some of those. And absolutely. Okay, everyone, have a great night. All the best. And if you have an injury, I wish you the best of health and the full recovery. And if you have a case, I wish you full justice and the maximum compensation. Okay, have a great night, everyone. Bye-bye.